Hello, my name is Aaron Brodsky, and I am going to present on an update from an in-house lawyer's perspective on IP issues, on patents, trademarks, copyrights, trade secrets, and just sort of give you the perspective of someone who actually works for a company as opposed to working as outside counsel. It's a slightly different perspective, I think, than what you might have working for a law firm, and so hopefully this will help you, if you're working for a firm, understand a little bit more about what your in-house clients might be perceiving in some of these recent cases. So let me dive in, and I want to start off by talking about this recent case, Unicolors versus H&M. This came out just a month or two ago from the Supreme Court, and this case got dismissed pretty quickly by a lot of observers who thought that it would just be one that wasn't going to make a lot of waves. And it's a straight up copyright infringement case. And the problem was that there was an error in the copyright registration. And the defendant said, hey, the copyright is invalid because there was an error, and that should prevent the copyright owner from asserting statutory damages. Amazingly, this went all the way up to the Supreme Court, and the Supreme Court held, okay, the error did not invalidate the copyright registration. This was somewhat interesting because, there was a question about errors of fact versus errors of law, and people were speculating that errors of law should not be. It should be assumed that everyone understands the law, and if you don't understand the law, and you make an error, well, there should be consequences for that. Errors of fact might be forgivable. Anyway, it was sort of that level of discussion. But I'll tell you, from an in-house perspective, I saw something completely different about this case, which is why I want to open up with it. And here is what was really going on. Unicolors, the owner of the copyright, was in fact a hugely sophisticated registrant, copyright registrant, and litigant. And I'll show you their docket in a minute, but they filed hundreds of lawsuits enforcing their copyrights. In fact, they had over 4,500 copyright registrations. And the issue, the error that was the subject of this case, was that multiple designs, and these are fabric designs that they were registering, multiple designs were listed on a single copyright registration. Now, you're only allowed to do that if the multiple works are included in the same unit of publication. That's the rule from the Copyright Office. But there was lots of evidence that, in fact, all of these fabric designs were marketed, displayed, licensed all separately. So what was going on that they were aggregating a bunch of these things into a single copyright registration? And in fact, the reason they did it is because they were cranking out designs of, people say, such minimal creativity and at such high volume, it wasn't even worth the $65 that it costs to register these designs individually. So they started aggregating them just to save money, knowing full well, allegedly, that you can't assert copyright to a grouping when, if you're really interested in the copyright in the individual work, you have to register it individually. And if you register a group, it's because that whole grouping is part of the work. So let's take a look at the actual copyright registration. And here it is. Each of these is a separate fabric design. And there, I don't know, if you count them up, close to 30 of them listed here. And they have names that, you know, EH105, and here's HH183, and here's EH119. These are just fabric designs that they, you know, create in high volume. There are 4,500 individual registrations, but, you know, perhaps over 10,000 of these individual designs, and they didn't want to blow the budget on copyright registrations. So, so this is what they did, and the question is, can they get away with this? Because what they were doing was looking for opportunities to actually assert copyright infringement against defendants. And if the Supreme Court had gone the other way, it's not as if they wouldn't have been able to refile their copyright registration and then proceed with their lawsuit. If they had to do that, though, they would have lost the ability to seek statutory damages and attorney's fees. And that's the big hammer in copyright litigation, is if you have access to statutory damages and attorney's fees, you don't have to prove actual damages, then you've got a huge amount of settlement leverage. And I'll show you what that looks like in a second. So H&M, which was accused of copyright infringement, and I'll show you the actual alleged infringement in a second, you know, they're saying, hey, look, prove up your damages, knowing that the damages were small and that the case wouldn't go forward if, in fact, Unicolors had to go that route. But Unicolors had a business of aggressively asserting copyright infringement claims, relying on this outsized statutory damages and the ability to seek their attorney's fees. So that was the issue here. And this is a case, and I'll talk about some additional cases under copyright law where you have a high volume of copyright registrations that are actually aggregated, asserted for the purpose of going out in high volume and filing lawsuits, typically against companies that are actually making products. So I come from that perspective. As an in-house lawyer, you have to be on the lookout for these people because, in fact, sooner or later you're going to bump into one of these. And H&M fought this. It's kind of interesting. There's $150,000 of downside here, but it went all the way to the Supreme Court. And you have to wonder, once again, how did that happen? And it's because H&M probably had an in-house lawyer who said, you know what, we're going to see this again and again and again. Let's get the rules right. So it got appealed all the way up to the Supreme Court. And by the way, I think, if I recall correctly, in the Supreme Court, the phrase copyright troll actually came out in oral argument. And so that really is the issue, sort of people abusing the copyright system for the purpose of high volume litigation. But take a look at the actual substance of the copyright infringement. Now, you may have to look at these materials separately and pull out a magnifying glass, but honestly, I don't see it. There is kind of a wavy design and some dots and some dots, maybe. The rest of this looks, nothing else matches up. Well, it's sort of a diamond pattern, but these are diamonds in a different pattern. You can imagine some designer just cranking out lots of different variations of this, and then Unicolors came across this H&M sweater that sort of looked like it, and probably sent a demand letter saying, you know, that'll be $150,000, please. And H&M started looking at what was going on and said, okay, let's see if we can get some rules here about the validity of copyright registrations. And so from an in-house perspective, this is a very unfortunate ruling from the Supreme Court. Basically, the Supreme Court is saying, sorry, but we think that the statutory language excuses this sort of behavior with respect to copyright registrations, and we're not going to invalidate the copyright, even though we know, because there were amicus briefs from a number of people pointing out, you know, the alleged troll problem here, said, well, we don't care. We're going to make it easy for people to get their copyright registrations, and if Congress wants to do something about it, it's going to have to be solved legislatively. So no relief from this kind of behavior from the Supreme Court. I was very disappointed in this. But people who make their living in high volume copyright assertions, I'm sure, disagree with me. Take a look at this slide. It comes from the Lex Machina database for litigation in federal court. And let me just point out a couple of things. First of all, 263 cases actually filed by Unicolor. These are all copyright cases. You can imagine that there's some multiple of that got settled long before the case got filed, but 263 cases actually got to the point where Unicolors couldn't settle it and then just went to court. 216 of them just settle right away. When you're facing statutory damages, there is, and you don't even want to go there. They probably asked for some amount less than what statutory damages would otherwise allow for, and so rather than hire a law firm, you just pay it off. And that's the business model. And you can see this is all pretty high volume. 20 of these cases, Unicolor actually won, but 14 of them were default judgments. So don't ever, in-house lawyers know, you don't ever want to have a default judgment registered against you. That's just sort of a losing proposition right out of the gate. But they did win on one case out of the 263 went to trial, right here. The two others went to summary judgment, 3 consent judgments. But look at this, a couple of defendants actually fought back, and one defendant actually won in trial. So a little bit of activity, but by and large, I sort of expect that this has been a very profitable litigation campaign overall. And this is the business model. And you may wonder, okay, well, there's a business model for high volume copyright infringement in fabric designs, but you'll see that the same business model is used for pictures, music, and open source software. And let me show you how that works. Pictures are pretty easy. You file hundreds, maybe thousands of copyright registrations on photographs, and you post them all online. And you can use a similar technique, same thing with music. Let me show you what the music one looks like. You post them in a way that's looks like it's free. Here's one. This is an actual snippet from a website saying, hey, the sound of your next web video starts here. Free, free. And there's free all over that website. Free. Okay, what's the catch? If you haven't encountered this before, the catch is when you go and you look at the actual license that governs either the music or the picture, you'll see that it's free for non-commercial use. And so what happens at large companies? You have employees frequently dispersed. Maybe it's an international company. You might have employees all over the world. They're putting together advertising material, marketing material, videos. Companies post videos to YouTube all the time. Customers love it when they can just watch the video and see how the thing works. And you need background music. This is not popular music. Everyone understands you can't copy, top 40 hits and use those. These are just sort of background tracks of arpeggios or drum beats or, sort of just background music. And many people can be confused by this if they haven't been trained by their in-house legal department. They will say, hey, the website says it's free. They'll go and they'll grab the track, put it on the YouTube video, post it on the corporate channel for YouTube. And what happens next? Well, the way you monetize this, you get it out here, you sort of attract people to use your music or your pictures, and then you have an automated bot crawler that just runs in the background all the time and checks on background music, checks for pictures, and looks for matches. And those bots are so good. They can match even snippets of music or cropped pictures. And as soon as they find one, you get the letter, the demand. And the demand always leverages, of course, the statutory damages. Frequently, the first letter that you'll get from people that run these businesses will be almost like an IQ test. They'll demand outrageously high amounts of money, hoping that you don't even know what the statutory cap is. And then you have to negotiate down from there. So that's how the high volume copyright registration, high volume, you have to actually entice people to use these in a commercial way when the license, buried in the license, is non-commercial use only term. What about open source? This same model works also in open source. How do you entice people to copy your software and put it in a commercial product? Well, one way to do it is you have a dual licensing model for the exact same software. So one download of the software will be free for non-commercial use only, but that's embedded way down in the license where engineers might not notice it. The other is a commercial license. And the reason they do that is because sometimes in companies, engineers who are not savvy to this will say, oh, I need some software that does this. They go and look on the web and say, oh, it's open source. And they'll download it, and the download will get detected. They know where it downloaded to, and then you'll get the demand. So watch out for that. And in the background, we already know that the courts are not impressed about whether or not you think that business is a troll model. So this stuff happens. By the way, I'll just mention for the in-house lawyers or people that advise companies that I've seen some pretty creative attempts to lure people with pictures. Sometimes you get marketing people who are savvy to licensing issues. They will look for a Creative Commons license, and they'll say, oh, okay, now I get it. There's a license, Creative Commons, that's sort of available, but there are different types of Creative Commons license, and one of them is Creative Commons attribution required. And of course, attribution is not embedded in the photo. You have to be sophisticated enough to know that you need to put a little attribution under the photo if you use it. And people will come after users who download Creative Commons attribution required when the attribution is missing. So anything to sort of entice people who are not savvy about what's going on into doing this. And with statutory damages, it's a very lucrative business model. So watch out for that. Okay, this is interesting. Staying on the subject of copyright law, this is a case that's coming up for oral argument. Cert's been granted in this one, the Andy Warhol versus Goldsmith. And this is going to be a fascinating case on fair use. This is the copyrighted image, and this is the Andy Warhol artistic rendering. And if you look, you can see it's clearly derived from the copyrighted image. The question is it fair use? And the line there has got to be very, very difficult. And line drawing drives in-house lawyers crazy because businesses need certainty in order to, make their plans, execute, sell products. When the law puts fuzzy boundaries and you don't really know if it's a derivative work or a transformative fair use, it's just an invitation for a dispute. And it'll be interesting to see what the Supreme Court does with this case. Keep in mind that fair use is statutory. At one time, there were a number of people who thought, well, we think we understand fair use. It's statutory, and commercial exploitation of something that looks like a derivative work is definitely going to be outside of the statutory framework for fair use. But then, this case landed at the Supreme Court, and you remember this probably from a couple years ago. This was Android basically copying over 10,000 lines of code from Java, and after I think close to a decade or maybe more than a decade of litigation, it was deemed fair use. So, and that went all the way up to the Supreme Court. So with that as a backdrop, I think it's possible that the Supreme Court has a much broader view of what constitutes fair use than what the rest of us had assumed before this case came out, and now I think the Supreme Court, might reinforce that. But this is a case that is still, even after this decision, many companies that have software products often wonder about APIs and about other uses to make one software platform compatible with another software platform, or make one software platform similar to another software platform. Is it fair use or not? I think it's still unclear enough that you could end up in a lawsuit. So maybe with this new case, the Andy Warhol case, we'll get a little bit more clarity on that. This needs to be in a presentation just because it's a reminder with copyright that sometimes you don't even know whether a copyright is valid or whether somebody really owns copyright. You may remember this picture from a few years back. This is the famous monkey selfie. And the question was, since the monkey took the picture, who owns the copyright? And there was a lot of dispute about that. And it also reminds me of the famous dispute over the Happy Birthday song. Once again, you had someone asserting copyright ownership of the Happy Birthday song, collected millions in royalties over the years, only to have a historian go back, because copyright is such a long duration, go back, look at the facts, and figure out that no, in fact, the copyright really was in the public domain. So keep in mind that someone asserting copyright may or may not have it. Okay, let's switch up a little bit and talk about trade secrets. And here, this is how I like to think of it. There's sort of a spectrum of confidentiality. And at the far end, you have things in the public domain. And sort of in the middle here, you've got things that are business confidential, typically protected by non-disclosure agreements or confidentiality provisions. And Then, at the far end, you have things that are so confidential and so valuable as secrets that they get special protection under both federal and state trade secret acts. Now, this is a fuzzy boundary between public domain and business confidential. You can have, for example, databases where the individual elements of data are known. Is the database itself confidential, or is it still in the public domain? Anyway, fuzzy boundaries over here. And if you happen to get on the wrong side of this boundary, you still have to have someone prove up damages, and this is not a scenario that turns into a bet the company kind of litigation. But at this boundary between business confidential and trade secret, you know, if this is just sort of cloudy, this could become a massive liability for the company. If you get caught on the wrong side, thinking you're on this side of the boundary, where damages are relatively contained if something goes wrong, and then it turns out someone successfully argues that no, in fact, that was a trade secret, and all of a sudden the remedies for misappropriation of trade secrets are far, far greater than the remedies you could get for mere business confidential misappropriation of business confidential information. And let me show you an example of that. This is a recent case. Believe it or not, this is a device that surgeons sometimes insert into people's spines. And it's sort of scary to even think about this, but here you had Life Spine with, you know, the original device, and they sued Aegis Spine, which has a very similar device. There are actually multiple patents involved here, and this is kind of an interesting trade secret case because the device itself was the subject of patents, and the device itself was subject to whole marketing campaigns to teach people, surgeons in particular, what it is and how to use it. And it's a piece of hardware. You can hold it up and look at it. And you might, if you were advising a company, well, could there possibly be a trade secret in a piece of hardware? This is a piece of metal, titanium or something. Could that device have trade secret status? And the answer, surprisingly, was yes. So what could be trade secret? If you can go out and buy one of these, what's the secret? And Lifespine was successful in arguing that the exact dimensions of this were never disclosed in the patent and were never disclosed in the materials that got circulated to surgeons for advertising and promotion. And so the exact specifications of this were in fact a trade secret. And you could say, well, you could buy one and measure it. How could that be a secret? And the answer was, well, the supply chain on the sales side, or actually the sales chain, went through distributors where every unit was tracked, every unit was governed by a confidentiality agreement, and really all the way into the operating room, no one basically could touch this thing without having an NDA in place, and therefore it would not have been possible for an ordinary person to get a hold of one of these things to measure it, and therefore the dimensions were held to be a trade secret. So kind of a surprising outcome that you can have a product for sale and it's a piece of hardware, and in fact still have trade secret status in spite of all that. So that's just what I just said. Okay, so trade secret pitfalls. That case that we just talked about with the spinal implant was really a situation of make versus buy. You had two companies, one company said, well, we'll just resell the other company's device. And at some point, they decided, yeah, you know what? I think we can make something similar on our own and have a better business outcome. And so they terminated the reseller agreement and then came out with a similar model. I think any make versus buy decision that happens inside a company is fraught with peril, because you can end up with accusations of trade secret misappropriation in sometimes surprising ways. So it's just something to look out for. If you're disengaging a joint venture or a longtime business partner, once again, you may think, hey, this is all public information. I'm way over into that left side of the confidentiality spectrum where things are public domain. I'm free to go and make my own. And then you can get sometimes blindsided by successful arguments that its trade secret still applies. This is a huge pitfall. Sometimes businesses get pretty far along on non-disclosure agreements that actually allow for the exchange of trade secret information. And if you accept trade secret information, you have to be really careful about how you handle it. And if the people accepting it don't know that it's trade secret, you could have a real issue on your hands for that company. You need procedures. If you burden business teams with too many procedures, you basically slow down the business, and then the legal department becomes the lightning rod for business people who are trying to move fast. So you balance protection, practicality, but sometimes you can trip up over this if in fact something leaks out by mistake. And if you have procedures and you don't enforce them, that's even worse, because that will get brought out in court. So you have to be careful about making sure that if you do have written procedures, that you actually enforce them. And then, of course, this is a classic problem. If you hire employees from competitors, you have to make sure that you're not going to run into problems with them bringing over things that they remember that may later be asserted as trade secrets by their former employer. Okay, let's talk a little bit about patents and trademarks. On trademarks, I like to start off with this, because for those in the room, it's a reminder that we're going to have beer in just a little bit. For those watching online, this is an example of a product with literally no trademark, kind of rare. And if you drink something like this, you get what you deserve, because you don't know where it came from, and you have no expectation of any level of quality. So trademarks are definitely important. This is a case that caught my eye because it basically involves a local business, Elevation's Credit Union, and they got into a trademark dispute with another credit union based in Utah. And the merits of this, are open to debate, but first and foremost, this is every company's fear that in the process of policing a trademark, and you send out a cease and desist letter, and you can see Elevate, and Elevations, these names are very close, so there was probably a policing operation going on. But when you send a cease and desist letter, that's not without risk. And in this case, Elevate Credit Union filed a declaratory judgment action to resolve it in their home court in Utah. So that's the first thing. Regular policing actions could haul you into court on a declaratory judgment action. So that's the first takeaway. The other interesting part of this decision was there was a a long discussion about the decision-making process, the evaluation of the name by the marketing director at Elevate. And when Elevate was choosing a name for itself, they had an in-house person, not a lawyer, who was going through and trying to figure out if Elevate Federal Credit Union was an available brand that they could select from among others. And the decision-making process in there, I think, should be a warning sign for lots of companies where the in-house expertise on trademark law was not as good as it should have been. And the thought process, I mean, they did some browser searches, they did some searches with the USPTO, but when you read the selection criteria, and the judge sort of summarized what was going on, you realize that there are a lot of ways to trip up in-house if you don't actually clear trademarks with outside counsel that can do a professional search and opinion. So this one was just interesting for that pitfall, being that the in-house expertise might still lead you into a dispute. So they invested a lot of money in this brand, Elevate, and now both Elevations Credit Union and Elevate Credit Union, have to litigate this to resolve it. Okay, we'll wrap up with a discussion of some patent cases. We didn't get any patent cases in the current Supreme Court term, but we are waiting to hear about cert petitions for two big cases: American Axle on Section 101 of the Patent Act on eligibility, and then also enablement, this Amgen versus Sanofi case. And so these both highly anticipated cases. In American Axle, the issue here was that the Court of Appeals for the Federal Circuit found the patent to be abstract. And the patent was actually on, just as it says, it was on a drive shaft in a vehicle. And it was about a system for damping vibrations in the drive shaft of the vehicle. And there was a lot of surprise and anxiety around the fact that something so tangible as a drive shaft in a vehicle could actually be ruled abstract. For a long time, people thought, well, if you're claiming a physical object and you could literally drop it on your foot, there's no way that that thing could be abstract. So how did you get to a ruling that this particular patent was abstract? And actually, for companies that build products for a living and use patents mostly for defensive purposes, this looks like a reasonable outcome. You don't want to grant a lot of patents where you recite prior art elements, and then at the point of novelty, there's just sort of a functional claim a functional element in the claim. And that's what was going on with American Axle. Yes, there was an axle, but axles or drive shafts are well known, they're prior art. And then the claim had a wherein the vibrations in two different modes get damped. And you damp the vibrations by essentially inserting material into the hollow shaft of the drive shaft. And as the drive shaft spins, that damps the vibration. And there are two different modes of vibration, and the claim is, well, you just damp two different modes of vibration. So it was functionally claimed after reciting a prior art piece of hardware. And where you claim things at a functional level, without actually claiming how you did it, how you accomplished it. So yeah, you damped vibration, but you didn't say how. You didn't claim the exact steps or methods or the actual process used to damp the vibration. You just said wherein the vibration got damped. Well, that got ruled as abstract. So we'll see what the Supreme Court does there. This one on enablement is also very interesting because it'll affect how companies have to write specifications to make sure that the specification of the patent is going to be complete enough so that if you claim at the genus level, you'll actually enable all the different species. So this is an issue of designing around. And if you claim broadly at the genus level, and you want to stop people from coming in and claiming rights to individual species by saying, well, my claim is scoped to all the species within the genus, but in fact, the specification doesn't lay out all the different possible species, then the question is, what level of detail is required here? And I can't really speak to biotech, but in software, this is going to be a big issue because software is often claimed at a high functional level, and people need to know if they can design around that with specific software claims that may be a variation of that. And if you do that, what level of detail in the specification is required. So this will be an interesting one to watch, not just for the biotech people, but also for everyone who files software patents. Here, this is a case that I worked on for a long time. This is Trimble versus Per Diem. And I have to say, when I was in law school and studied personal jurisdiction, I wasn't exactly attracted to the subject matter. It seemed, so procedural, and I didn't really understand, well, why would anyone even care about personal jurisdiction? But it makes a huge difference because for defendants, you can end up in a very expensive, inconvenient forum or the home court of your adversary. And certainly in the world of patents, there are certain courts that like to attract patent cases, and you may have opinions about whether you want to be in those courts or not. And the question came up about personal jurisdiction in the case of a non-practicing entity that sent demand letters and had extensive conversation in attempts to license their patents. And the question is, can they only be sued in their home court? They're a non-practicing entity. They don't have actual operations. So where can they be sued? Only in their state of incorporation? So we raised that question. And in this case, Trimble filed a declaratory judgment action in the Northern District of California. The non-practicing entity was a corporation with a headquarters in the Eastern District of Texas, but with no employees there. The sole employee was based in Washington, D.C. And the question is, can we haul them into court with a declaratory judgment in the Northern District of California? And the answer is yes. If there's sufficient activity that makes that reasonable and fair in the eyes of the law. So it purposely avails itself because it conducted activities, licensing activities in the Northern District of California. And then just more recently, Apple did the same thing to Zip It Wireless, once again, a declaratory judgment action. And Apple filed in the Northern District of California, and the court here once again explained that there's no general rule that demand letters can never create specific personal jurisdiction. So I think the takeaway here is that if it matters where you litigate, you have to pay attention to how much activity you have in your licensing negotiations with targets, because you may actually be subject to personal jurisdiction in your target's home court. So, interesting personal jurisdiction issue in the case of patents. Okay, finally, I'll just wind up with a couple comments on high-stakes patent litigation. This really is something that no in-house lawyer ever wants to engage in, at least if the focus of the company is making products and selling products. The last thing you want is high-stakes patent litigation. But sometimes it's inevitable, and it's not. It gets thrust upon you. And here, there is a big lawsuit in multiple jurisdictions between WorkGen, a company that makes these asphalt milling machines, and Caterpillar. And this has been an interesting one to watch because both sides were very sophisticated, very large companies. Both had very sophisticated, very large in-house patent departments, and both had very credible patent portfolios. And when they got into this patent dispute, they asserted multiple patents against each other. I think the patents were all of high quality. The expectation was that all of these patents were sort of validly asserted, and yet they have been on both sides encountering sort of mixed success, with radical downsides to both companies. Patents have been invalidated. There's been ITC action that could potentially disrupt businesses. So it's really a lot of downside risks in high-stakes patent litigation. Even if you're forced into it, the outcomes here are not only very expensive, but also can really upset business operations in ways that are very hard to predict at the outset. And then last but not least, there's this case. And this one is just fascinating to contemplate. It is a lawsuit where a design patent has been asserted on the shape of essentially potato chips, or very thick wedge potato chips. This is the design patent, and this is the accused product. It's kind of interesting because normally design patents, you sort of expect, an exact comparison between the design and the actual accused product. But of course, potato chips are going to be a little bit variable. This case was filed in 2016, not yet resolved, on a design patent. So once again, final takeaway, litigation can last far longer and be far more expensive than anyone would have predicted. So from an in-house perspective, that's a real issue to think about when you're faced with potential litigation. Drives a lot of settlements because if you stick to your guns, it may be a long road in court. So that's it. Thank you very much for listening to my presentation, And that is the last slide.